having an opinion on what constitutes a racial group, what constitutes racism, what constitutes a discrimination based on race or color. We have to know what a race or color is. And so you get into arguments about, does racism exist? Does black or white exist? Is really what you're looking at now. Not, you're arguing about definitions about what exists. And so you're getting, again, to sort of the real question that Alito has here is, Alito is basically saying racism doesn't exist anymore. That racial discrimination is not something that majorly affects political activity anymore. This is questionable, I think. Blah, blah, blah. The language since the baseline against which to attest the opportunity of minority voters, the opportunity that other members of the electorate have to elect their preferred candidates. To understand this baseline was nailed down the meaning of 3 terms: less opportunity, other members of the electorate, and elect. So this is going to constitute a bunch of definitions. Alito, several concerns of the court, but Alito especially, really likes to get into this. Like, well, this is the definition of the word. We're going to look at the definition. We're going to look at the dictionary. And this is something I think is problematic in that it really gets into the question of is the Constitution a living document or a dead document? Is the Constitution something that we can reinterpret, or is it something that we need to say, well, if we want to change how the laws work, we need to change the laws themselves. We need to rewrite something in the Constitution. We have to put in amendments. We have to pass new laws. Modifying something we did before. We can't just decide what the definition of something is. The definition of something is exactly what the definition is. But this is something which I find Alito is utterly and completely hypocritical about. We see earlier where he's saying this is not a precedent. We've just assumed it is. We've just assumed it in our rulings, but it's not a real precedent because we haven't ruled directly on it. I'm ruling not directly on it for the first time today ever. Therefore, I'm not actually overthrowing anything. And I'm going, well, no. The VRA has been active for years. It has affected how we run our country. It has been upheld in many ways through the assumptions of the court. Regarding the ruling you are making today, this is settled law. And Alito is saying, well, according to my definition, it isn't. Well, but according to its activity, whether it has acted as settled law or not, it has definitely acted as settled law. This is a precedent you are overturning. And Alito just, he loves to say this. Say, well, if you look at the definition from this specific era, or look at this definition here that I decided, then all of a sudden everything makes sense. And I'm not overthrowing any precedent. I'm just bringing it back to how the ruling was beforehand. What do you mean you're not overthrowing a precedent? You're just bringing it back to how it was beforehand? Then you're overthrowing a precedent. Because if it was one way at a certain time, and then it was a different way now, then it was decided differently. At some point, right? Something changed, something moved. You're overthrowing precedent. And Alito insists he's not doing this when he absolutely, completely does this. It's infuriating to read. What is the 1994? The party told you to ignore the evidence of your eyes and ears, and this is exactly what's going on here. Alito enjoys this. It's annoying to think this is what we're reduced to. And this is what the legal system of the United States of humanity after thousands of years is reduced to. Well, I like this definition. Okay, well, what about the other definition, the other definition, and the other definition? I mean, shoot, I've had problems with my brother which would have made more sense than this. I had disagreements with people about the exact thing. Well, it turns out that we were just talking past each other the entire time because we had different definitions of whatever the argument was about. And this is really what's going on here. Alito says, well, this is my definition, and it's obviously the correct definition. And the mere fact that there are opposing viewpoints proves that the definition is not as set in stone as Alito claims it is. He is, in this ruling, definitely unwilling to admit that other people's views exist, really, or have any merit whatsoever. Later on, he'll talk about the dissent here, saying, well, the dissent doesn't really understand. And he's written this in other rulings as well. He's like, well, the dissent really doesn't understand what I'm doing here. Or the dissent makes an argument which doesn't hold water. And I'm like, it seems to hold a lot of water. The dissent isn't just some hack. The dissent is a justice with a long history. This dissent is another person on the Supreme Court. It's one thing to say, I disagree with the interpretations of my colleagues. It's another thing entirely to say, my colleagues don't even understand the argument. I mean, the dissent in this opinion is saying, well, Alito understands perfectly well what he's doing. The majority understand perfectly well what they're doing. They're just saying that they're not doing what they're doing. And this is definitely something Alito is guilty of, I would say. In any event, the opportunity of these members of the electorate to contribute their votes to winning causes, whatever opportunity results from the application of the state's combination of permissible criteria. Okay, so basically what he's saying here is that federal law should not affect elections. The opportunity of the members of the electorate to contribute their votes to winning cause is whatever opportunity results from the application of the state's combination of permissible criteria, not the federal combination of permissible criteria. Federal laws should not affect state elections. This is the will of the old Confederacy. I don't mean the Confederacy of the Southern states. I mean the Confederacy of the United States. I mean the idea that states' rights are stronger than the right to the federal government. The states' laws trump the federal government, at least as regards voting, right? The idea that the people represent the people in a state elect state representatives to represent their state, and those people go to the federal government. They do not elect federal officials directly. The federal system. And therefore, if a state wants to be racist, or a state wants to disenfranchise urban voters, or a state wants to disenfranchise rural voters, like California I think sometimes does, then the state can do whatever it damn well pleases. I mean, this is something that I think as we go into the other confederacies of the southern states, this was the hypocrisy, I think, that really brought down the Civil War, or brought the Civil War upon us. The southern states, it seems to me that one of the main causes for the Civil War in the United States was probably the Fugitive Slave Act. The claim by the southern states that they could go into the northern states, take escaped slaves, and bring them back down south. Right? And basically saying, look, there's one law for you and one law for me. And my law says I can do whatever I damn well please for the federal government. But your law says that you have to stay within your state boundaries. And this is incredibly problematic. It basically look, the 15th Amendment of the United States only ever applies for direct racial speech. That is the only application of it. If I don't say I'm against black people, I don't say I'm against white people, when I pass this law, then this law is totally fine, no matter how it affects white people or black people, or how it affects Indian folk. or how it affects the Chinese, the Japanese, the Koreans, or Arabic speakers, or whoever it may be. Basically saying that, okay, as long as you can come up with some possibly reasonable explanation for why you're passing a racial law, then it's fine. Notably, this reasoning directly allows something like a poll tax, or directly allows something like a literacy test, or directly allows something like a property requirement. Because you can come up with reasonable explanations for these. And this is exactly and entirely and completely what we saw in the South, specifically after the Civil War, right? You had poll taxes, which black people were less likely to afford. You had property requirements, which black people were less likely to have. You had straight up literacy tests, and when when 90% of the black population are slaves, never wanted to read, literacy tests disenfranchise them by design. So this is a thought process, right? Where states' rights trump federal rights, and yet, strangely enough, local rights don't trump states' rights. Essentially, it says, the entrenched power of our system has the right and the ability to remain in power and do whatever it takes to remain in power. This is anti-democratic completely. This is the doom of the United States. This is why we had a civil war. Because the entrenched powers in the southern states saw their economic and political power on a federal level disappearing. And so they decided to rebel because they didn't constitute a majority of the country anymore. Or a majority of the political power anymore. And so what you see today is that same activity taking place, in that this reasoning is being used to say, well, we don't have to look at race. Racism doesn't exist. We don't have to, the federal government should not have power to determine what states do. We can come up with some reason that affects how people should vote or should be able to vote. We could reduce the number of polling places, or we can require ID to vote, and that may affect some people more than others, but that doesn't matter. It doesn't matter the effects, it matters the reasoning. But I think as anybody who has ever argued with an obstinate brother, as anyone who has ever argued with a boss who just doesn't get why this is an issue, has anyone who has ever dealt with a stubborn teacher or a stubborn student, is anyone who has ever dealt with a bad customer or with a company that just won't keep to an agreement, you can argue and come up with reasons for anything. It's a lot more difficult to modify results. And this is, I think, why the VRA focus on more on the results, because it's harder to hide that. With reasoning, look, someone can always come up with another BS reason for whatever they want to do. You can always come up with some logic, you can always come up with some fallacy which will seem or to appear to hold up this activity as perfectly reasonable and fine. Whether it is illegal or not is another question. It's like the requirements for mediation. Like you can't sue when you sign an agreement with the company, right? And they say, well, you can't sue us. You have to go to the mediation, and we're going to pay for the mediator. And in some states, that is straight up illegal. But they'll put it in the what do you call it? In the contract anyway, just hoping you won't have the mindset to think about that. Just hoping that you won't know they wrote something illegal. Just hoping that they aren't caught, because they aren't caught often enough. And yet, if you look at the results, you go, well, you're going through a lot of mediation instead of being sued, and it's hard to hide that. As opposed to, well, mediation is more reasonable, it's quicker, it's faster. We don't have to go through all this legal stuff. You don't need a lawyer. Again, if someone tells you if someone ever at any point is in an argument with you, or is on the other side, or is engaged with money that involves you in any way whatsoever, and they say you don't need a lawyer, that is exactly precisely when you need a lawyer. Right? That is precisely when you need somebody to at least have a look at this and go, well, what's actually illegal? What's actually going on here? What's actually the effect here? Not what they say, not their reasoning, because look, con artists are all over the place. People fall for scams every day. I've fallen for scams. You've fallen for scams. And you know it. You damn well know it. Don't look at the reasoning. Look at the actual activity. Right? Look at the results. Okay. In any event, the opportunity of those members of the electorate to contribute their votes to a winning cause is whether opportunity results from the application of the state's combination of permissible criteria. So what is the actual don't ask, does the state have a reason for doing this? Ask, what is the effect of this instead? You're going to get a much clearer answer of what's actually going on. And if you are seeing the black population being cracked into several districts so they constitute a majority of no district, then I don't care what the reasoning is. The effect is going to be racist in its activity. Now, you can ask whether the racial group affected by this constitutes enough of a group for this to matter, right? Constitutes a contiguous geographical area, or votes as a political bloc. But the effect is still there. Whether it's strong enough to matter, whether it is something that you can change without negatively affecting another racial group, these are all the questions to ask. But the effect is still there. You can argue about how difficult or problematic it is to change this effect, but the effect's still there. The racial effect is still there, whether you have good reasoning for it or not. But that is a different question to ask. How racist does an effect have to be for you to do something about it? Does it, if one more white person than a black person is affected by this law, is that an accident? Is it just how the numbers worked out, right? Is it because of the difference between urban and rural populations? Is this just like a bad part of town? Is this a good part of town? Is it a history of a whole lot of money going through in the past? What's going on here? Is a question to ask. But if it is racist or not, in effect, that's often easier to answer. Now, this can, of course, be misinterpreted. You can say, well, if you look at this group using this definition, then it's racist. But if you look at this group using this other definition, then it's not racist. And then you get into a political argument. So to me, at least, the question really, truly to ask is, how much of an effect does a person's racial group tend to have upon their voting preference? If there's a strong effect, and if being black is linked to voting in a specific way, then this constitutes enough of a racial issue for us to really take a very close look at the discrimination. If the fact that you're black or white or gray doesn't affect how you vote at all, then it doesn't really matter how you break things up as regards race. But because in this country, I think it's very obvious that we tend to see groupings, right? I mean, you look at a population of Chicago, for example, by racial group, and it looks very stark. And I remember that was a shock to me. First time I went to Chicago. And of course, all this comes back to common sense and definitions and arguments and so on and so on. But I think Alito in his majority opinion, is just trying to escape all that. He's trying to say, look, racism doesn't matter. The states can do whatever they want. We're not actually overthrowing precedent. And I'm going, these are all very questionable things. And particularly what I dislike is it'll come up, but his dismissal of his opponents. It's one thing to say my opponents are evil. It's another thing to say my opponents are stupid. And was it the dissent tends to like to say my opponents are evil, and Alito, the conservative majority, tends to like to say my opponents are stupid. Except I would say, well, it's a whole stupidity is a little rarer than might be assumed at this level, and evil is much more common. Not big evil, not horrid evil, but the little ones, the little discriminations, the little racial views, the little I'm just going to ignore this problem, or I'm just not going to care about those people. And so Alito and Thomas may be perfectly fine people to know and be friends with, but the little evils are magnified when you have great power. Perhaps that's what power corrupts means, in that your actions are magnified, so your good parts are better than good and your bad parts are worse than bad. Yeah, here says Section 2 does not intrude on states' prerogatives to draw districts based on non-racial factors. They may use traditional districting factors such as compactness, contiguity, maintaining the integrity of political subdivisions, preserving the core of the existing district, and protecting incumbents. And I think this last one is the really problematic ruling. And protecting incumbents. And no, it does. That last one is not a reasonable activity for a political state to take. Drawing your districts to protect your incumbents is anti-democratic. Is completely and totally, utterly anti-democratic. It says that instead of the people electing their voters, instead of the voters electing their representatives, the representatives decide their voters. It is the opposite of democracy. It is the destruction of the will of the people. But I'll get into that ruling later. Okay, it says, we have made clear when a state defends a districting scheme on the grounds that it was drawn for partisan purposes, plaintiffs have a special burden to overcome. To prevail, the plaintiffs must disentangle race from politics or proving that the former drove a district's lines. Basically, this means, among other things, ruling out the competing explanation that political considerations dominated legislators' redistricting efforts. If either politics or race could explain district's contours, the plaintiff has not cleared its bars. Okay, so there's a whole lot of citations here and so on and so on. But what he's actually saying is, as I reiterated, if black folk tend to vote Democratic and you are a Republican majority in the state, breaking up the districts so that Democrats do not gain a majority of the vote in any place, then that is perfectly fine. If you're breaking up the districts in such a way that the black folk do not have the ability to elect someone as a group to political office, then that is bad. That is not allowed. If these are the same thing, then it's totally fine. Again, our leader was saying here, look, racism doesn't exist. If it does exist, it is incredibly rare. And if people vote as a racial bloc, then we can disenfranchise them anyway. Therefore, if black folk, for example here, do not vote like they are all one black group, then we would not break them up. Because black folk vote like black people, we can break them up. If they did not vote like black people, we would not break them up. If race affects politics, then we can break up racial groups. If race does not affect politics, we cannot break up racial groups for political districts. Like, do you see how this is a catch-22? If black folk vote as black folk, then you can break up their district. If black folk do not vote as black folk, then there is no district to break up. But when I say if black folk vote as black folk, what the state is going to say, what the Republicans in Louisiana are going to say is, if black folk vote Democrat, we can break them up. If the black folk would just vote Republican, then we would not have to break up their districts. But they're not going to say that, right? They're going to say, if the Democrats, if these people, put them in quotes, these people, quote, end quote, quote, these people, end quote, would vote Republican, we would not need to break them up without ever actually defining these people, right? The fact that there are these people, those people like that are all black, that doesn't matter. That's not important. The fact that those people are all in the cities, that doesn't matter. That's not important. The fact that those people are all farmers or are all in this one valley, or that those people are all next to a nuclear power plant, or are all downstream from a bunch of factories, that doesn't matter. None of that matters. Nothing matters except that they vote Democrat or Republican. Except they vote for us. And if they don't vote for us, we can break them up. So any group whatsoever, they can break up if they don't vote for them. So if race exists in such a way that it affects political processes, then political processes will act in such a way as to disenfranchise racial groups. And this is perfectly legal. This is actually what he has held. That if racial groups vote as a racial bloc, then they can be broken up. This is the straight up bit here. So it is not, you are not being disenfranchised because you're black. You're being disenfranchised because a bunch of folk are black. I mean, this is racism with a mask on. You can see the argument here again. Ilya was saying, look, racism does not exist. Racism is not a factor. Race, in fact, racial discrimination in any way along political processes does not matter and should not matter, and we will not take it into consideration, ever. Unless, of course, it exists. If it exists, then we can break it up anyway. So it's a catch-22, right? If racism doesn't exist, that is, if racism doesn't exist, then we can break up groups. If race does exist, we can still break up political groups. So we can break up political groups whether or not it is racist. As long as we don't say we're attacking black folk or white folk or green folk. We're attacking urban folk or we're attacking farmers. That's totally fine. It's euphemisms. It's double speak. It's 1984 flat out. It is contradictions within the very substance of the argument. right? And then he says, this interpretation does not require abandonment of the jingles framework. We need only update the framework. Okay. Again, you have Alito claiming I'm not doing what I'm doing. It does not require abandonment of the framework. We need to only update the framework. That is abandoning the framework of the Giles ruling here, right? The ruling which said, that a racial group need to look at a racial group and see if it matters for political districting. It needs to vote as a group. It needs to be contiguous, and so on and so on. I mean, what is this sentence? What is this insane lying sentence? This interpretation does not require abandonment of our previous decision. And you only update our previous decision. That is, our previous decision was wrong. That's what he's saying here. He's saying, do you hear the contradiction here? Like, what is this? The third time he's done this? Just in this one ruling? Just in this one opinion? This interpretation does not require abandonment of our previous decision. We need to only change our previous decision. We do not need to, this does not require that we change our previous decision. We need only change our previous decision. This is hypocrisy. This is a contradiction within two sentences right here. Okay, and then you get to the real meat of this, right? First, four historical developments are of particular note. Vast social changes occurred throughout the country, particularly in the South, where many Section 2 suits arise. As this court has recognized, things have changed dramatically. At the time of the Act's passage, the nation had faced nearly a century of enriched racial discrimination in voting, an insidious and pervasive evil. But the Voting Rights Act led to great strides in the ensuing decades. By 2004, the racial gap in voter registration and turnout had largely disappeared, with minorities registering and voting at levels that sometimes passed the majority. Black voters now participate in elections at similar rates as the rest of the electorate. Blah, blah, blah. Okay, notice what he says here and what he doesn't say. Okay, he's basically, so he starts out, look, there were great reasons for the VRA to be passed. Those reasons are gone. Look, African Americans vote in record numbers. African Americans can vote. African Americans do vote. African Americans vote in similar rates as the rest of the people. African Americans even turn out at higher rates than white voters. But at no point does he mention anything about, do black voters vote differently than white voters? This is the essence of racial discrimination. Do they vote differently? Do white folk and black people vote differently? If they do vote differently, then there is a reason for this. Just because, you want to look at historical developments, right? Well, one thing we know is that there are a hell of a lot more ways to disenfranchise a group than to just not let them vote. You can make it by redistricting be in such a way that their vote does not count. And Alito throws this out the window. He ignores this entirely. He ignores the concept of racial blocks and voting entirely. He says racism does not exist. Race does not exist. That is his viewpoint. Racism did exist, but that was many years ago, and we're past it now. And I would be amazed to see the majority of people in the United States agree with that. Look at here. A full-blown two-party system has emerged in the states where Section 2 suits are most common. Giles arose in the context of a one-party system which black and white voters had starkly different voting patterns despite their affiliation within the same party. In the area involved in Giles, an overwhelming majority of white voters did not vote for any black candidate, blah, 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 blah. And so he's saying, look, back then, you only had one party, and black voters voted differently than everybody else. And now you have two parties. Well, I wonder why that is. Could it be that by allowing black folk to vote, because they vote in a different way than the rest of the white folk in the country, in the state, you now have two political parties which reflect two particular tendencies, two particular voting tendencies? That's, again, one of those things, this seems a little strange. Why would a two-party system have emerged? What he's saying here is, he is being, okay, this is a blatant political hackery by Alito. As long as they were Republican, it was fine. But now that you got Republicans and Democrats, it's not fine. What? You say the black folk voted differently, so we disenfranchised them. And now today, the black folk are voting differently, so we're just disenfranchising them. It was wrong in the first case, but it's right in the second case. Why? Because now it's Republican versus Democrat. Now suddenly it matters because it's Republican versus Democrat. Because it's this conservative versus liberal, because it's red versus blue. When the circumstances are exactly 100% exactly the same when Giles is decided versus when this decision is taking place today. Exactly the same, but now he is just interfering in political decisions. This is, again, utter hypocrisy by Alito. This is hypocrisy by all the judges who signed on to this judgment, this opinion, because the court has repeatedly held that it should not involve itself in political decisions. It is involving itself in political decisions right now in this case, exactly. And this section here clearly shows it. That is my reading of this, right? That Giles, the ruling in Giles and the ruling today are exactly the same circumstances, that black folk are voting against the Republican majority. And the third significant post-Giles development, the court's decision in Rucho. We held that claims of partisan gerrymandering are not justifiable in federal court. Basically, as far as federal law is concerned, a state legislator may use partisan advantage as a factor in redistricting. Basically, if you are if the political masters of a state have not only their ability, but also the right. It is a right enshrined in the Constitution that the federal government cannot begin to mess with. Right? The political masters of a state have the right to disenfranchise, to effectively disenfranchise whoever the hell they want in order to keep themselves in power. This, again, is completely and utterly undemocratic. It is my personal opinion that Rucho is going to be one of those decisions which results in the destruction of democracy in the United States if it is not overturned. In the fourth development, we can use computers to draw maps and so on and so on. Okay, I'm getting onto the later hours, so I'm gonna speed up a little bit and go over it because I'm just repeating myself at this point. And the mention of Rocha was just infuriating in particular. right? So he's saying Louisiana's enactment of this SB 8 triggered strict scrutiny because the state's underlying goal was racial. The state never hit the ball, blah, blah, blah. Basically, he says no compelling interest justifies SB 8. Basically saying, look, you cannot even look at race. You cannot argue race. If you say that this map is racist, then you cannot do that. You cannot say this map is racist. You cannot say this map has racist effects. You cannot say this map has racist causes. The only way to say that this districting is illegal is if you can have you're gonna need in writing. You're gonna need opinions in writing. You're gonna need recordings of the people who drew these districts saying they are intentionally disenfranchising all the black folk. If they can come up with any other reasoning, if you do not have clear evidence of them, being card-carrying members of the KKK, then they can do whatever they want. They can crack and pack districts and keep themselves in power to disenfranchise any particular group for any reason whatsoever, as long as they don't say that it's because they don't want the black vote to matter or they don't want the white vote to matter. If they simply don't say that, if they think it, if they act it, if the result is that way, if instead of black they say urban, then instead of black they say poor, if instead of white they say farmers, then it's totally fine. Then you get this textual argumentation, right? Well, they didn't say in this text, and this word does not mean this. The definition of that word is not the definition of the other word. Therefore, these words are not the same. It's like saying, right and correct are not the same word. They don't mean the same thing. What? Right and correct don't mean the same thing? They aren't synonyms? It's... You get into this argument over again, is the Constitution a living or a dead document? Well, if it's a dead document, then these are definitions, and if you want to change it, you have to go change the wording, the words itself. You can't just arbitrarily decide that something... what our ancestors decided actually means this now. Except, of course, that we've been doing that all along. And this is what Alito gets into. Alito specifically does this by using his definitions. Because anytime you choose a definition, you are cherry picking the definition, right? It's ripe for abuse. And then he's saying, look, it doesn't match the Giles preconditions, blah, 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 blah. To show racially polarized voting, the Robinson plaintiffs offered evidence that black and white voters consistently supported different candidates, but their analysis did not control for partisan preferences. Okay, what he's actually saying here, the plaintiffs didn't meet their burden in the second and third Giles preconditions. Okay, this says... The Robinson plaintiffs show that black and white voters support different candidates. But because the black and white voters support candidates from different political parties, that doesn't matter. Look, black and white folk vote differently based on their racial identities. But it doesn't matter. Because their voting preferences evidence themselves in political parties. How the hell else are they supposed? What is a political party? So what he's saying is the only way the black vote matters or should matter in Louisiana is if it votes Republican. That is the actual activity that is taking place. This is the viewpoint, a living constitution document. And so what he has done is say the only way the black vote will matter in Louisiana is if they vote Republican. The only way to change the political makeup of Louisiana at this point, according to Alito's understanding here, or according to my understanding of Alito's understanding, perhaps I should say, is by changing the Republican Party from the inside. You cannot vote Democratic. You should not vote Democratic. If you vote Democratic, your vote in Louisiana does not matter, and should not matter, and ought to not matter. In fact, it is the enshrined political right of the Republican majority in Louisiana to ignore and disenfranchise and attack the Democratic viewpoint because it's a political party. But if all the black folk voted Republican, they couldn't ignore that. So you say, look, the black folk voted like the white folk. If black people would just shut up and vote like white, like the rich white planners and business owners and polluters and factory owners want them, and farmers want them to, then they can count. But if they have a different viewpoint, if they support different candidates, they don't count. That is what he says here. That is his argument. Because they support people from a different political party. It's hypocrisy. It's not just racial discrimination. It is something much worse and much deeper. It is anti-democratic. It is saying that the vote of a large group of people, not necessarily even a minority, right? It could be a majority. You could have a 60% of the majority, 60% of the people in a state voting Democratic, and if you can crack it just right, you can still end up with over proportional Republican representation in the state. Or the other way around, overly Democratic representation in the state. I mean, California is guilty of doing this right now. And it's the exact same thing. It is saying that political parties is trying to enshrine political parties and the rights of political parties to control states. And by controlling states, to thereby control the federal government. It is saying that a political party, it is setting the country up for, well, I think what we have now, right? A stalemate between the Republicans and the Democrats, where they fight each other because the other side is Republican or Democrat, not over reasons or ideas or causes or rights or values, but simply because the other side is not part of our tribe. You know, you go and read Washington's farewell address, and this is exactly what he argues is the major danger. This is, you look at the problems between Jefferson and Jackson, and this is exactly what happens, right? And you look at it today, and 2010 with Obama and McCain and McConnell and whatnot, and this is exactly what happens, and this is exactly what's happening today. Just these people who feel that their tribe is the best, their tribe has rights to exist, their tribe is the true spirit of America. And but by holding on to the past in this way, by trying to enshrine these identities and allow them to disenfranchise large members of the community in order to maintain their own political power, you set up the country for an explosive redistribution of political power. It's the same problem we have everywhere, right? The same problem you see with dictators the world over. The same problem you see with the person above you at your job sometimes, right? Look, dude, you're 75. Retire. Relax. Let the country go. Let your power go. You are not You do not need to be in charge. You do not need to protect us from ourselves. That people can govern themselves. The youth will take over. And if you keep trying to treat everyone who is not of your exact viewpoint as ignorant, stupid children, then all you do is ensure that ignorant, angry children take over. The duty of the elderly is to ensure a peaceful transition. When kings, when dictators, when political power causes the most problems is in the handoff, is in the unwillingness of some group to just move on. To say, I did my part, I was here for when it mattered, my voice was heard, and now I am ready to go away. Instead, they hold on, and some viewpoint that is anachronistic just tries to strangle the future. It is the past attempting to eat up the future. And that is what we see here. You will see these contradictions arise. You will see someone say, well, we have changed so much. And as someone, a whole lot younger than Alito, I'm saying, we have not changed that much. I've read the history books. I've talked to people. We are not over the racism. We are not over the problems of kings and princes and political power. The dangers that Washington, in his farewell address, talked about are still alive and well today, and someone like Alito is feeding them. It is exactly not. I mean, if Alito was doing the same thing for the Democrats, I would say the exact same thing, right? But the decision to say, look, it doesn't matter if they're racist. It doesn't matter if people are disenfranchised. All that matters is the people in power to stay in power. And this is a problem. The people in power do not have the right to stay in power. The people in power have their time in the sun. They have been elected for their moment. And they need to be aware that their moment shall pass. All of us will die. And trying to hold on just strangles, just damages and destroys the democratic ideal of the United States. I expect the same thing to happen in 60 years when my generation is getting ready to pass on. Right? There will be people in power who say, well, I think it should be this way. And I'm going, no. Look, you get in power and then you leave. This is again why Washington left. He didn't want to be king for life. He didn't want that precedent. This is not what we should be doing as a democracy. The decision here. Okay, so then he goes here, and the dissent's arguments are fully addressed. But if you read the dissent, that is not their opinion. The dissent states over and over again that our decision requires the plaintiff to prove discriminatory intent. Yes, that is exactly what it does. You have to prove discriminatory intent. That is my understanding of what Alito was arguing here. And again, you see the hypocrisy, you see the doublespeak. He's saying, well, we haven't actually done that. Yes, you have. Right? The circumstances must give rise to a strong inference of racial discrimination. No. Racial discrimination can exist. The argument of this opinion says that racial discrimination can 110% exist. Right? You can disenfranchise all those black folk if they vote as a racial group. That is totally fine. You just cannot say you're doing it for racial reasons. But if they vote that is, if black folk vote as a racial group, you can disenfranchise them. A strong inference of racial discrimination does not overthrow the districting. Right? You must have a proof of racial intent, is what this opinion has held. Alito saying otherwise is a lie. In this opinion, in this state right here, right, the circumstances must give rise to a strong inference of racial discrimination. Alito is lying. Contrary to dissent's assertion, we have not overruled Allen. Yes, you have. Again, we see this again. We haven't overruled it. We just modified it. That's a lie. Right there. That is a contradiction. We haven't overruled it. We've modified it. Then you've changed it. Then you've overruled it. Race and politics must be disentangled. Unless a racial group votes in politics. Then it's not a racial group, it's a political group. This is doublespeak. The black folk may vote as a group, but if they do, then we can disenfranchise them because they vote as a group. Well, why are the black folk voting as a group? Because they're one racial group. So if race exists, then you can disenfranchise them. If race doesn't exist, you can still disenfranchise them. It's about voting blocks here. It's not about race. It's about vote. You can get the real meat of Alito's decision here. It's not about racial groups. It's about voting blocks. He's saying that anyone who votes the block can be disenfranchised. All right. So then I'm going to end here with just Thomas and Gorsh concurrence. This is just a gloat. Thomas here says, I join the court's opinion in full. This court should never have interpreted Section 2 of the VRA to effectively give racial groups the entitlement to roughly proportional representation. By doing so, the court led legislators and courts to systematically divide the country into electoral, districts along racial lines. Today's decision largely puts an end to this disastrous misadventure in voting rights jurisprudence. As I explained more than 30 years ago, I would go further and hold that Section 2 of the VRA does not regulate districting at all. Therefore, no Section 2 challenge to districting should ever succeed. Basically, Thomas is saying that looking at race in any way whatsoever should be illegal. Looking at race in any way whatsoever is wrong. The VRA is a blatantly unconstitutional law. And he's just saying, well, I think that race should not be a consideration in any decision or in any law, that the state should act in such a way that it assumes racism does not exist and cannot exist. As regards political groups, racism can exist towards individuals and for individuals, but not towards groups or for groups, is Thomas's opinion here. And he is just straight up saying, I said 30 years ago that racial discrimination in any way as regards federal powers should be illegal, and now we finally ruled it. Thomas at least is clear and honest here. Alito lies and double speaks and attempts to deceive people and says he's doing something that he says he's not doing something that he is doing. Thomas is just like, look, I was right, y'all suck, I win, haha. And it's not something that I think he should be proud of stating here. He's just saying this is him gloating, essentially. This is him saying, haha, I won. And so that's the opinion and the concurring opinion in this ruling. As I think you can understand, Louisiana versus Callais. That's my opinion of it, my reading at least of it, from the textual facts. And I think you can understand I am not in favor. I do not think this was decided impartially. I do not think this was decided with a democratic mindset. I do not think this was decided with an understanding of history or the 15th amendment. I disagree with this opinion.